Hello, I'm Dominic Walker, JMW's Inside Man. I've got two guests today, Peter Barnard, who's a partner within JMW's Commercial Litigation Department, and Layla Kelly, who's a senior associate within JMW's Commercial Litigation Department. Both specialise in property litigation. So, Peter, if I can ask you first of all, I know that both you and Layla have been involved in the case of Fattal and Fattal. What happened in the case?
Certainly, Dom. So we acted on behalf of the successful claimant, William Fattal, in relation to the ownership of 106 Nottingham Terrace in London. William had purchased the property in his sole name in 1972. In around January 2014, he transferred it to his brother Elias for no consideration, on the basis that there had been a proposal in the early 90s made orally for William to transfer the property to his brother on the basis that he had been paid the sum of £400,000. Neither party in the case suggested that there had been a gift from William to Elias. William's case was that in the 2014 transfer had been pursuant to a mistaken belief that he had been paid the £400,000 in or around 1990, when in fact he hadn't been. So the claim sought relief for the consequences of that mistake and other relief on the back of that. Elias's case was that the brothers owned the property beneficially as tenants in common in 1972, pursuant to what's called a common intention constructive trust. And the proposal in 1990 was for him to acquire William's 50% share in the property. Elias suggested that whilst he couldn't recall the specifics of the arrangement, there would have been some transfer between the brothers, either by way of a transfer across some of the jointly owned companies, by a director's loan account, a trust account, or some other similar device that would have reflected the payment of £400,000 to William in or around 1990.
And so, Layla, what was found in the case and what's the significance?
So we had a 4-day trial, and the master held that there was no evidence at all that Elias had actually paid for the property at the beginning, or that there was an intention between them that they would jointly own it. The master also found there's no evidence that he paid for it subsequently or contributed for it subsequently in a meaningful way. And that therefore the transfer that our client entered into in 2014 could only have been done so by way of a mistake by him and was a void contract. So it applied some recent case law, which I think is the first time that it's been applied. It's from last year. It's a case called Ali and Dink, and found that a constructed trust could arise in those kind of circumstances. And therefore the Elias, even though the property had been transferred to him legally, he held it on trust for our client, as though it was in fact our client's property. Then the question was more, well, how does that work in terms of a remedy? Does our client just get a big chunk of money to compensate him, or does he get the property back? And happily, the court ordered that in those types of circumstances, the transaction can effectively be unravelled and the property can be transferred back to our client.
And Layla, how can you help individuals who have a dispute with the property?
Well, I mean, this is quite niche, but certainly circumstances like this, where there's a trust kind of situation that's arisen, it's something we can help with, or just more generally property disputes. There's a whole bunch of us here with lots of experience that can help with any kind of issue.
Layla, Peter, thank you very much for your insight. If you'd like to contact Peter and Layla, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.